For the fourth lecture in this lecture series, I will be sharing in a little more depth another source of international law mentioned in the first video: general principles of law recognized by civilized nations. On this topic, we will examine four key questions. One, why this source of law is a source of international law. Two, the concepts of general principles of law. Three, the meaning of civilized nations. And four, examples of some of these general principles. Now, the why. A reason for the inclusion of this source of law is to assist in making decisions where there is a gap in law. Generally speaking, when there is a gap in law, a matter before a competent court or tribunal can be declared as non-liquid. This term has its roots in Rome, and it translates to "it is not clear." And so, when a competent court or tribunal fails to decide the merits of an admissible case for reasons such as inconsistencies in law, vagueness or ambiguity of rules, or even absence of suitable laws, the court will decline to resolve the dispute. This consequence also relates to international law. As such, general principles of law recognized by civilized nations become a source of international law to cushion the effect of declaring a case non-liquid. This allows the international court or tribunal to lean on general principles of law from municipal law, general principles of law having origin in international relations, or general principles of law originating from legal logic and even legal relations to reach an equitable decision or resolution. As Judge Tanaka puts it in his dissenting opinion in the Southwest African cases, where he says, so far as the general principles of law are not qualified, the law must be understood to embrace all branches of law, including municipal law, public law, constitutional and administrative law, private law, commercial law, substantive and procedural law, etc. To the question, what are general principles of law? The idea of what general principles imply has been met with some degree of vagueness. In making some clarification, paragraph 53 of the 2019 report of the International Law Commission on General Principles deems general principles of law referred to in Article 38, sub 1, sub c of the Statute of the ICJ as having a general and fundamental character. So such principles are general as a result of their content, having a certain degree of abstraction, and fundamental as a result of the fact that they underlie specific rules or embody important values. Also, what are civilized nations? It has been suggested that the allusion to civilized nations refer to enunciated principles that have a very general purport and were indisputably common to all major Western legal systems. This notion has been criticized as antithesis and incompatible with the relevant provisions of the United Nations Charter. According to Judge Amon's separate opinion in the North Sea continental shelf cases, he emphasized that the founding fathers and protagonists of the law of nations must have intended a system of non-discrimination among states. Having said that, we will examine some examples of what these general principles of law recognized by civilized nations are. One, we will look at the principle of Estoppel. Estoppel is an equitable principle recognized under many municipal laws. It takes root in common and Anglo-American law. Estoppel bars an individual from resigning from a previous representation. In international law specifically, the International Court of Justice held, specifically in paragraph 130 of the case concerning delimitation of the maritime boundary in the Gulf of Maine area, that the doctrines of Estoppel and acquiescence both follow from the fundamental principles of good faith and equity. So, under public international law, Estoppel operates to protect legitimate state expectations. So, where a state has altered its legal position on acts or conduct induced by another state or state, the doctrine of Estoppel can come into play. We will see that the jurisprudence of the ICJ examines a wide range of the concept of Estoppel. For example, in the North Sea continental shelf cases, in paragraph 30, you will see that the ICJ held that, and I quote, "It appears to the court that only the existence of a situation of Estoppel could suffice to lend substance to the contention that the Federal Republic was bound by the Geneva Convention on the continental shelf. That is to say, if the Federal Republic were now precluded from denying the applicability of the conventional regime by reason of past conduct, declarations, etc., which not only clearly and consistently evinced acceptance of that regime, but also had cost Denmark or the Netherlands in reliance on such conduct detrimentally to change position or to suffer some prejudice." So here you will see that the court is saying that Germany is barred from resigning from previous representation where Denmark and the Netherlands have altered their legal position as a result of the representation previously made by Germany. Also, in the Argentine-Chile frontier case, the Court of Arbitration stated, and I quote, "There is in international law a principle which is moreover a principle of substantive law and not just a technical rule of evidence, according to which a state party to an international litigation is bound by its previous acts or attitude when they are in contradiction with its claims in the litigation. This principle is designated by a number of different terms, of which estoppel and preclusion are the most common." Another general principle of law recognized by civilized nations is the principle of non-interference. In paragraph 255 of the case concerning military and paramilitary activities in and against Nicaragua, the ICJ held that the court has also found that general principles of humanitarian law, including a particular prohibition accepted by states and extending to activities which occur in the context of armed conflicts, whether international in character or not. By virtue of some general principles, the United States is bound to refrain from encouragement of persons or groups engaged in the conflict in Nicaragua to commit violations of Article 3. And so we do see here that the court refers to the principle of non-interference as a principle accepted by states and extending to cases of armed conflict, whether having an international character or otherwise. Having said that, other examples of general principles of law recognized by civilized nations are res judicata, laches, impartiality of judges, and good faith, amongst others. So, overall, in this lecture, we addressed very briefly why general principles of law recognized by civilized nations are a source of international law. Also, we have addressed what the concept of general principles of law are. We've also talked about the meaning of civilized nations in this context, and we have looked at some examples of such general principles of law recognized by civilized nations. The month of November has been an amazing month. In November, we brought to you 4 lessons. In our very first lesson, we talked about basis of international law. In our second lesson, we talked about one of the sources of international law, which is international conventions. In our third lesson, we talked about international customs as a source of international law. And in this lesson, which is our fourth lesson, we have touched briefly on what general principles of law recognized by civilized nations are as they relate to being a source of international law. Next week, for our very first video in December, we will be looking at the last source of international law mentioned in the statute of the ICJ, which is judicial decisions and teachings of highly recognized publicists. So I want to say thank you so very much for joining in, for being with us throughout the month of November. Remember to like, share, subscribe, and hit the notification button so that you're notified when there is a new video. Thank you.